So it's very happy for me that Paul had to be out of town on a family matter, because it allows me to honor a revered friend in Henry, and also to introduce a person that I deeply admire, Anne Marie Slaughter. I always say when I speak in private and public, Charlottesville's own Anne Marie Slaughter. I think people need to be reminded that she grew up here. Her parents have very strong attachments to this institution. I think John Jeffries just told me that we've bought our third Anne Slaughter landscape, which is a proud acquisition. You can see two hanging in the new Cart Center. Anne Marie, of course, grew up here and then went on to a brilliant career in academia at Chicago, Harvard, Princeton. I think I would assert she became our country's foremost foreign policy public intellectual during this time, written several books. My favorite is A New World Order. She may have others, but to me that really captured a whole body of work in terms of unpacking the idea of actors that make international relations, getting us beyond the state, but reminding us how the state is important. Then in 2009, she followed her fellow Princetonian George Kennan to become the Assistant Secretary for Policy Planning, a job that he created. I believe she was the first woman to hold that position, and I think in every way fulfilled his great legacy. At the end of that tenure, she published a provocative and certainly in our household a compelling account of the challenges that face women in ambitious positions as they seek to juggle family commitments with their service to the nation and their career development. Soon to be a major American book. She has just recently taken on the position of head of the New America Foundation, moving to Washington in July, is that right? September. So we're very happy that she's moving even closer to town, and we'd like you to give a warm Charlottesville welcome to Anne Marie Slaughter.
Thank you. It is great to be home. I have to just say that although I've recently been perhaps best known for elevating the cause of women, my father and uncle will not forgive me if I don't also add that they attended this fine law school in addition to my mother's paintings. And as I'm constantly meeting people in Princeton who say, "Oh, you grew up in Charlottesville, are you connected to the university?" And I say, "Indeed. Have you exercised in the Slaughter Rec?" It gives them a whole new perspective. So it's also wonderful to be here to be able to give this lecture, and I will be talking more about Henry in the course of my lecture. I think 40 years on, not quite, I can also say there were many reasons to come back and do this. Most, of course, to honor Henry, but you know, the Abrahams have real pull with me. Philip took me to the prom. You know, if I look back and remember being a junior at St. Anne's Belfield, that was a true gift, and it certainly merited my coming back. And so I have a particular bond with the entire Abraham family. So Henry Abraham has spent his life teaching generations of students, and we just heard from one, about the Supreme Court, about the rule of law, about the living justices or the human beings that bring the rule of law alive. I'm going to argue that rarely have we needed those voices as much as we do today. That is what just happened. So 59 detainees are currently on hunger strike in Guantanamo. That figure may go as high as 100. 15 are being force-fed through a nasogastric tube. That means they are being physically restrained, tied down completely, and being force-fed for many hours at a time. The immediate trigger for this hunger strike that could take up to 100, and as I said, 59 have been on strike for weeks now. The immediate trigger was a search of Qurans, but everyone from the Muslim advisor at Guantanamo to the International Committee of the Red Cross to the general of the Southern Command says that the real motive behind this hunger strike is a complete sense of despair and hopelessness that essentially what are now 166 people in Guantanamo have been forgotten. Some of those detainees have been there 11 years without charge or trial. Since 2002, a total of 779 detainees have been held in Guantanamo. No one has been brought to Guantanamo since 2008, or 2009, when President Obama became president. A number did manage to leave. Most recently, 2 Uyghur Muslims from China were resettled in El Salvador. We have various detainees, various parts of the world. And last year, a detainee died, a Yemeni, in what appears to have been a suicide. When President Obama gave his first State of the Union address, closing Guantanamo was one of his highest priorities. This year, he didn't mention it. And that is apparently part of what has triggered these people with the only way they know and the only capability open to them to get the world's attention, to resort to starving themselves, either to actually kill themselves and or to remind all of us that they are there. So the first question is, are they legally detained? Are they being held legally? Think about that. 11 years without charge or trial. The Obama administration says yes, and the Bush administration agreed. In 2010, Harold Koh, the legal advisor to the State Department, gave a speech to the American Society of International Law in which he laid out a justification under both international and domestic law for indefinite detention without charge or trial. He says, as a matter of international law, there are 3 different foundations for being able to hold these detainees. The first is that we are fighting a war of self-defense in Afghanistan, a war begun after 9/11, clearly was begun in self-defense, and that the opponents in that war continue to undertake armed attacks against the United States in Afghanistan and elsewhere. Second, in fact, in that war, and where we originally captured many of these detainees, we're working with a consenting government. And third, the UN Security Council has authorized that war in a series of resolutions. And in those resolutions, the UN Security Council has authorized the use of all necessary measures to actually, for the NATO forces to fulfill their mandate. So under those, war and self-defense, a consenting government, UN resolutions, all necessary measures is deemed to include the detention of prisoners of war, as we have done in many other wars. Harold Koh said, this is effectively, we are detaining these people to prevent them from returning to war, returning to belligerent status. That's the international law justification. As a matter of domestic law, according to the legal advisor, Harold Koh, the Obama administration rests its authority on the authorization for the use of military force that was passed in 2001 by Congress after the attacks of 9/11, and that statute allows the president to use all necessary and appropriate force, against those nations, organizations, or persons that the president determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th, 2001. So note all of that. Planned, authorized, committed, aided, but the attacks that occurred on September 11th, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States. So the domestic law is a statute passed by Congress after 9/11 that authorizes all measures against those who planned or committed those attacks, and then to prevent those people's future acts. Harold Koh made clear that unlike the Bush administration, the Obama administration grounds its authority to detain people at Guantanamo and previously in other places around the world, not on the Constitution, but only on that statute. And that's something I will come back to. The Bush administration also found authority under the president's commander-in-chief power under the Constitution. And of course, the commander-in-chief power is far broader than any statute. The Obama administration says, no, we don't look to the commander-in-chief power. We look to this statute. So I have to point out that this position, the position of the administration I served and the position of the previous administration, has just this week come under very serious bipartisan attack. The Constitution Project convened a task force on detainee treatment that has been headed by two former members of Congress, one Republican and one Democrat, Asa Hutchins and James R. Jones. Hutchins from Arkansas, Jones from Oklahoma, both distinguished members of Congress who have gone on to distinguished careers. The task force included a former ABA president, Claudia Kennedy, who is the first woman to achieve three-star general status in the U.S. Army, Tom Pickering, a former Undersecretary of State and one of our nation's most distinguished diplomats, William Sessions, the former head of the FBI, a past president of the American College of Physicians, a well-noted religious ethicist, and a retired Army Brigadier General from Utah, who has also served as a Republican state legislator, and a university professor on Christian ethics. It's a very carefully picked task force. That task force this week released its report in which it found, the vast majority of that task force, all but two, found that our authority to detain those people in Guantanamo is explicitly tied to our authority to wage war in Afghanistan. And since the president has said that we will end our war in Afghanistan by the end of 2014, the majority of the task force, all but two, says they support, and I quote, moving swiftly to deal with all the prisoners currently held in Guantanamo and closing the detention facility in accordance with the cessation of hostilities by the end of 2014, as the law of war will no longer be applicable. They go on, they have a detailed proposal as to what to do with the various prisoners there. Some should be tried in U.S. courts or before military commissions with the same procedures that you would get in Article III courts. Others should be transferred to countries where we can be certain they won't be tortured. And for those few who are deemed to be still a threat to the safety of the United States but can't be prosecuted, and many can't be prosecuted because the evidence was obtained by torture, and hence we can't use that evidence in U.S. courts. And for those people we can't prosecute and we cannot send them abroad, they would be continued to be detained, but they would be brought to the U.S. mainland and their cases would be regularly reviewed. That's the view of a bipartisan commission, a very distinguished bipartisan commission, that our detaining of these people is they're only prisoners of war as long as we are fighting a particular war in Afghanistan, and that is going to end. You have not heard anything like that from this administration. Again, the administration I served. There has been no mention of closing Guantanamo, and certainly no mention of closing Guantanamo by 2014, a year and a half away. So when we see 59 hunger strikers who are quite willing to absolutely refuse food and water to the point that they have to be force-fed, they are saying we have been completely forgotten and ignored. And if, in fact, we can end the war in Afghanistan and we continue keeping them there, we are violating some of our most precious legal canons. I can remember as a child asking my father what habeas corpus meant, and him telling me it means present the body. You cannot be detained without reason and then trial. I should also note that this same commission task force unanimously found that force feeding is torture. Republicans and Democrats, maybe the few things that they agreed on this week. So that is detention. Let me turn to drones. It may be that my reminiscences about my prom date are going to be the high point of this lecture for all of you. I wish this were a more cheerful subject, I truly do. So in September of 1976, actually just when I first went to college, in September of 76, a former Chilean ambassador to the United States and a very distinguished Chilean public figure named Orlando Letelier and his American assistant, a woman named Ronnie Moffett, were blown up on Sheridan Circle in Washington. Any DuPont Circle, Sheridan Circle, not far away, Embassy Row. In a car, driving around Sheridan Circle, the car exploded. It was the work of the Chilean government. This was later demonstrated, part of Operation Condor. Just imagine if that were a routine occurrence. Imagine that if suddenly you are driving anywhere on a highway or in a city and your car suddenly explodes. Imagine if the Mexican government, in pursuing its war against narco-traffickers, decided to pursue its intended quarry across the border into El Paso and to simply launch missiles at said quarry in El Paso, right in broad daylight, right in the middle of the city. That's essentially what's happening in Pakistan and Yemen, in Somalia, now in Mali. Our drones have the ability to target a specific car or a part of a house. We are very careful to try to avoid civilian deaths. We really do everything we can, but inevitably, as happened with one of our targets, when his car blew up, he was an American citizen, so was his 16-year-old son. So inevitably, when we shoot a missile at a house, do we often kill civilians as well. So I start with this image of Washington, D.C. to give you a sense of what it would be like to be going about your business and suddenly to have a car explode, to have a house explode, out of the blue, literally out of the blue. So let's ask about the legal authority for drones. So again, let me take you back to the authorization for the use of military force from right after 9/11. It's all necessary and appropriate force against nations, organizations, or persons who were connected to the attacks on 9/11. There's little question that we are legally authorized, we the United States government and any NATO allies, but we the United States government are legally authorized to use drones in Afghanistan and Pakistan. It may not be wise, and I'll come back to that, but it is legal. That is, I think, generally recognized because we have been authorized by Congress, and this is a weapon in our arsenal. However, there is growing agreement on both the right and the left that if we are not in Afghanistan, Pakistan, because that's where the attackers who launched 9/11 were, or if we're not fighting Al-Qaeda, because Al-Qaeda was responsible for 9/11. So if we're outside Afghanistan and Pakistan and we're not fighting Al-Qaeda, where is our authority? Where does the president have authority to launch a missile that will destroy a house or a car or part of a city where the people on the other end had nothing to do with 9/11? And of course, there are many offshoots of Al-Qaeda. I'm not saying they're good guys, they're not, but they are not part of the attacks on 9/11, neither geographically or organizationally. The Bush administration would have said, well, but the president has power as commander-in-chief. These are people who are trying to attack the United States, and the president has power as commander-in-chief. As I told you, the Obama administration rejects that authority. The Obama administration does not want to expand the commander-in-chief power as widely as the Bush administration did. So the Obama administration says it bases its authority on that statute. And as I said, from the right and the left, people are looking at this, parsing the language and saying, in fact, Congress will have to repass that statute or amend that statute. Our president does not have authority under American law to do what he is doing. That's under domestic law. Let me talk a little bit about international law. So, very interesting argument recently that under international humanitarian law, in the law of armed conflict, this is certainly armed conflict, there is a least restrictive means test, which means, in English, if you can put enemy combatants out of action by capturing them, then you shouldn't injure them. If you can capture them without hurting them, you should capture them. If you can put them out of action by hurting them instead of killing them, you should do that. You might have to shoot at them, you might have to shoot them in the leg or whatever, but if you can get them without killing them, you should do that. So only if you can neither capture them nor wound them can you kill them. Now this is it's a pretty commonsensical principle. It's certainly the principle our soldiers would like when they're fighting a war, right? If you can be captured, you want to be captured. If you can be wounded rather than be killed, you want that. It's I think, quite compelling argument that this is the standard in the Geneva Conventions, and particularly in the protocol to the Geneva Conventions from 1977. There are other views. There are arguments that point out, in fact, using drones against individuals who are on our target list is smack on the line between human rights law here and the law of war here. And the law of war, in this argument, allows you to use any necessary means to achieve a military objective, such as long as it is not grossly disproportional to those means. The law of human rights, and you can think about that, think about our own criminal law, says, no, you need to use the least harmful effective means. So again, capture instead of wound, wound instead of kill. This is an active debate going on in international law right now. I think no one would argue under international law that we are still authorized to use drones based on 9/11. That, in other words, the Security Council authorization for the war in Afghanistan cannot extend to Yemen, Somalia, or possibly Mali. So I've given you two arguments that neither our detention of 166 people on the island in Guantanamo, nor our use of drones outside the theater of war in Afghanistan are legal, either under domestic law or international law. I want to suggest that there may even be a connection between these two. Since we cannot capture people that we believe to be terrorists, and we have good intelligence, I'm not saying we don't know that they are attacking the United States, but since we have no place to put them, if we capture them, perhaps it's easier to kill them. Our special forces are very effective. They could probably have captured even Osama bin Laden, although I don't fault them for killing him. I don't fault them for a minute. But we probably could capture a number of these people. But since we can't legally detain them, there may well be a link. So that's the legal case. Let me now talk more about the political case, even the moral case. And here I'm going to draw considerably on a wonderful testimony given by my friend John Bellinger, who I think is somewhere in the audience, who was the legal advisor, there he is in the back, who was the legal advisor when Secretary of State Rice was in office, and who fought very hard to uphold international law throughout the George W. Bush administration with some success. So he has recently testified to Congress also about the use of drones and has spoken out about the dangers of using drones the way this administration is using drones, building on the George W. Bush administration. And he points out, we should uphold the rule of law because we believe in the rule of law and because our power flows from our values, that when we are seen around the world to violate the standards we say we hold ourselves to, we are much weaker. Our allies and our enemies are far less likely either to respect us or it's much easier for our enemies to recruit against us. So that's the straightforward moral case, and honestly, standing at the University of Virginia in the Thomas Jefferson Center, I am not going to belabor this point. It seems to me it is the creed that I was raised with, that we believe in upholding the rule of law. But even if you don't accept the straightforward moral case, the value-based case, take the instrumental case. None other than John Brennan, who is now the head of the CIA, but was, of course, the top counterterrorism official for President Obama, says that the effectiveness of our counterterrorism efforts depends on the assistance and the cooperation of our allies. In other words, if the British and the French and the Germans and the Australians and all of our allies will not share intelligence with us, we cannot fight terrorism. They typically have a far more restrictive view of international law than we do, e.g. they read it more restrictively and they absolutely uphold it. And already many of our top allies are getting very nervous about providing intelligence that could be used in a drone strike. They are afraid of prosecution under international law or domestic law. So just to give you an example, you can imagine if, for instance, we were to use a drone strike in Pakistan or let us say in Yemen, and we kill someone who was a dual national, a Briton as well as a Yemeni, or simply a Briton. The British government were found to have given us intelligence that allowed us to use that strike. That government, indeed people within that government, could be sued. So this is a violation of our deepest principles, but it also may make us far less safe because our allies do not see a legal justification. On a policy basis, we have U.S. generals worrying that the impact of drone strikes is far worse than their effectiveness. Remember, it was Donald Rumsfeld who said, the question is not how many terrorists you kill, it's whether or not the rate of new recruits is slowing and stopping. So if, in fact, you are doing things that make people so angry that you're actually increasing incentives to join al-Qaeda and its offshoots, you are hurting yourself by these policies. Stan McChrystal, our former chief general in Afghanistan, has said that he is very worried about these policies and that he doesn't think that Americans appreciate the tremendous resentment they create. And I just ask you again to imagine driving in Washington and suddenly having the car in front of you disintegrate because some government decided that that person was someone who was an enemy combatant. We also have to think about what's going to happen when every other country has drones. Many other countries do already: Israel, Turkey, China, Russia. You can manufacture a drone. I would depress you utterly if I headed down this front. But drones can be very small and they're increasingly easy to get. If you think that's sort of far-fetched, well, why would other governments use them in the way we're using them? China actually considered using a drone strike to kill a drug lord, a Myanmar drug lord, who was wanted in the murders of 13 Chinese sailors. So they're trying to go after this drug lord, and they think about, well, we could just take him out with a drone strike. If this starts to sound like your children and grandchildren's video games, it's not accidental. We could take him out, but actually in the end they decided to capture him alive because his information was more valuable. We don't want to live in a world in which governments can simply decide, well, we could capture someone and try them, or we could simply kill them through unseen, increasingly available unmanned vehicles. And the last thing to say, of course, is one of the reasons we use drones is, in fact, that, of course, there's no risk to us. No one's going to get shot down in the effort, right? That's what unmanned means. The operator of the drone is here in the United States. So they're very tempting to use and very dangerous. All right. We've talked about drones. We've talked about detention. You're all thoroughly cheery. Let me talk about the dilemmas that this raises, because the people who've grappled with these issues in the George W. Bush administration, and certainly many of my own colleagues in the Obama administration, have wrestled with these questions. They are not easy questions, and it is always easier to see what one should do when one is out of office than when one is in office. But it is also, in my view, our job, for those of us particularly who are lawyers, who are policy people, out of office, to try to hold our nation to its own highest standards. But the real issue here, and I'm going to talk about drones, but it's equally true of detention. The real issue on drones is not the technology. Does it really matter whether we use an unmanned missile from the air or a traditional missile or some kind of poison, assuming it's a legal weapon? It's not the technology, right? I mean, we could have gamma rays. We could have any number of technologies. That's not what makes this troublesome. And it's actually not even the targeting of individuals. I mean, under domestic law, we have a prohibition on assassinations of foreign leaders. But if you're at war, you are entitled to target any member of the other side's military. We are not targeting the civilian president of some country. We are targeting people who are actually enemy combatants. And if we're at war, that may not be wise as a matter of policy, but it is legal. So the problem is not technology and it's not targeting. This is something John Pellinger's pointed out, something Harold Koh has pointed out. The real question is whether or not we're at war. That's the issue. And again, as I said, if we're talking about what we're doing in Afghanistan and Pakistan, and we're talking about keeping people in Guantanamo only until that war is over, we're okay. That is the traditional law of war. But we're not. We're now talking about targeting people who are on a target list. We don't know that target list. We don't know what criteria were used to put people on that target list. There are Americans on that target list. We have no idea. I tend to believe government makes mistakes. Everybody else makes mistakes. Government makes mistakes. Who knows how somebody got on that target list, right? They may have had a really, really unpleasant falling out with someone who provided false information. So now we're talking about using drone strikes on individuals who are not connected to 9/11, who are not in the theater of war, who theoretically could be anywhere. Is that war? And this is a hard question, because on the one hand, you can say, look, these are all groups who are trying to target the United States. These are all groups who are trying to target our embassies, our tourists, our homeland. Surely this is war, right? They've declared war on us, and we are waging war back against them. Well, to go back to the legal definitions, where we are is the difference between crime and conflict, right? I mean, so think about this, or armed conflict. If you think about armed conflict, war, you generally assume an army. It's one of the reasons it's called armed conflict, right? You assume an army. And you can identify that army. They don't always wear uniforms, but you can identify who's in that army and what their war arms are. A crime, of course, is generally between individuals. A state can commit a crime too, but generally it's individuals. If we had a shootout, right, Wild West, that is not an armed conflict. It's not, I mean, it may be great theater, maybe many things. It's not an armed conflict. So generally, we've assumed that the difference is this between individuals or is this between states? The law of war has looked at that and said, well, when it's between states, it's an armed conflict of an international character. And when it's between a state and a non-state network, a terrorist network, a guerrilla group, then it's called an armed conflict of a non-international character. Lovely legal jargon. But then the question is, well, okay, fine, we got that far, but when does violence amount to armed conflict? If there's one attack, think again about the Letelier case. Let's say that had been an attack, they killed an American, let's say they were targeting an American. Is that an armed conflict? One killing of an American in an American city? What if it's 10? What if it's 50, but over time? At what point does the individual use or a group use of armed force, but against other specific individuals, equal armed conflict? 9/11? Yes. What just happened in Boston? Probably not. Terrible? Horrific? Mass murder? Yes. But is that armed conflict? Probably not. So, effectively, we're in a world where we have to develop a new set of categories. We need a new set of rules. We need, instead of dividing international conflict from crime, we need a category that integrates across borders, across categories. We need some kind of definition of mass violence where it would be bound by the same rules, whether it happened within the United States, whether it's the Oklahoma Federal Building, or whether it happens overseas, or perhaps when we have a mass murder with gun violence. We need some category that says when a certain number of people have been killed with a certain level of violence, here are the rules that apply. Now think what those rules might be. They might well include preventive detention. You might say, look, if there are people out there who can kill large numbers of individuals in mass violence, then it may not be the law of the war and it may not be crime, but we need rules. And we need those rules to be public, and we need them to be debated, and then we need them to be applied not only in the United States, but in other nations. Those would be rules that would apply equally to Mexican drug cartels, to the terrorists in Somalia. It would be a set of rules under both domestic and international law. We might have looser evidence requirements in such cases. We might actually have special standards with respect to providing weapons. You can imagine recognizing a category of threat and developing a body of law. This is where I come back to Henry Abraham, because that's how we do things in this country, right? We have rules. You have to, you put forward the rules, you debate the rules, you pass the rules, and then everybody knows them. And then courts interpret them. My civil procedure teacher used to say that law is the etiquette of ritualized battle. And what he meant was in the old days, we had knights with lances and they charged at each other and knocked each other off, right? And there were a lot of rules governing that. Today we have litigators and they meet in front of the court and in front of the judge and they do battle about what the rules mean. But it must be public. It must be known. It can't be some kind of standard that is applied by the president and his people, where criteria we don't know, and of course, we don't know to whom they're being applied or how. We need a set of rules. We need exactly the respect for the rule of law that Henry Abraham has spent his life instilling in his students. Let me just broaden the perspective beyond the law of force, beyond the law of defense of military force. We're actually facing a very similar dilemma in diplomacy. Because in diplomacy, again, we assumed it was all about state to state. We assumed that you had to have relations with another state, and to do that, you had to send an ambassador there. And you had to build an embassy, and you had to station people there, and they had to then send back, originally dispatches, and then cables, and now email. But we assumed that the only way we communicated with another state and found out about another state was for our government to go to another government. Now, of course, we have information from people on the ground all the time. We now have the capability to actually reach every person on the face of the earth who owns a cell phone. Secretary Clinton, in theory, and actually does in practice, could send a text telling everybody how great the United States was to every human being on earth. And in fact, we do use all sorts of media. Our ambassador in New Zealand has more people following his Twitter account and his blog account than read New Zealand's largest daily newspaper. That's a lot of people, right? That means New Zealanders are more clued in to what our ambassador is saying than their largest newspaper. That's, a kind of not very scary example, but in Beijing, we tweet out the air quality in Beijing every day. It means our embassy sends out a tweet and says, basically, you can't breathe if you go outside today. Our measure is not the same measure the Chinese government uses. It will not surprise you to know that ours is more accurate than what the Chinese government uses. We measure particles of 2.5 millimeters, and they measure particles only of 10. And the smaller ones, of course, are more dangerous. So we say, well, wait a minute, why? This is the truth. We live in Beijing. We are simply uttering the truth. But we are using a medium that goes out to the entire Chinese people. It actually goes out on Twitter, and it gets translated into Chinese and goes on to their social media. In Zimbabwe and Syria, our embassies communicate with the opposition on Facebook. We can talk to the young people through Facebook and Twitter far more effectively than we can through our diplomats. And obviously, we're accredited to those governments, so they're not very happy about having our diplomats meet with them. This is the same problem. A world that was once just a world of states is now a world in which states can communicate with people in society and citizens can communicate back to states. Our practices of diplomacy don't know what to do with that. We have no idea what rules ought to apply if the Chinese government says, please stop doing that. We say yes, they say, you're violating our sovereignty. You can't come to our country and tell our people what their air quality is. We say, don't be silly. We're just putting out information. And when we say we have relations with China, we have relations with your people, not just your government. Last thing I would say is the same is true in development. If you look at any global problems today, whether they're global health problems or environment or food security or water security or education or poverty reduction, all those problems, none of them are getting resolved only by governments. Just think about the Global Alliance for Vaccinations and Immunization, which has been a very powerful alliance reducing infectious disease through immunizations. That has lots of governments in it, but you better believe the Gates Foundation is one of the biggest players. And so too are countless NGOs like Doctors Without Borders or CARE or Save the Children. So too are universities and many private individuals. Suddenly, we used to give foreign aid. Now what we have are governments that give foreign assistance, but we have foundations, non-governmental organizations, corporations, playing a very large role, individuals, universities, research institutes. That world of states is a world suddenly of states and lots of other people. So in all those cases, we need a new set of rules. The law of war is the one that should concern us most, but the law of diplomacy and the law of development are similarly in need of a profound paradigm shift and people willing to write new rules, interpret them, and apply them. We need those rules because stretching our current rules is often a very bad idea. And so I will leave you with a quote from the Supreme Court from a justice I don't believe that Henry Abraham knew. It's not the original Marshall, but it is Robert Jackson, one of our great justices, in the Korematsu dissent. So you will remember Korematsu is the case in which a Japanese an American citizen of Japanese descent, was rounded up during World War II in California and detained without charge or trial. There was no charge except that he was of Japanese descent, so it was a racially motivated act. The Supreme Court upheld it, but Justice Jackson, one of our most powerful legal and moral voices, said, you know, it's okay if we want to let the military order stand. The military does lots of things in war, and not all of them are good ideas, but sometimes they are necessary. But he said, a judicial construction of the Due Process Clause that will sustain this order rounding up people based on their racial identity, is a far more subtle blow to liberty than the promulgation of the order itself. A military order, however unconstitutional, is not apt to last longer than the military emergency. Note that. We're now in a military emergency that doesn't have an end. But World War II certainly did. Even during a war, a succeeding commander can revoke that military order. But once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court has for all time validated the principle of racial discrimination in criminal procedure and the principle of racial discrimination in criminal procedure and the principle of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. That's the power of law. Once you've said it's law, it's in the rule books, it can be interpreted and argued and applied far beyond the original circumstance. That is why, if we say today that the law allows an executive to decide who lives and who dies by death from the skies, we will find that principle stretched and applied in ways we do not trust and cannot imagine the danger that it will do both to our country and to the world. We need new rules and new courts. Henry has educated generations of students, not lawyers, but undergraduates and graduate students, ordinary citizens, to understand the necessity, the power, and even the fragility of law. His service, both in scholarship and in teaching, has been immeasurable. That is why it is a great honor to have been able to give the Henry Abraham Lecture today. Thank you.